Judge Maloney is one of 6 federal judges in the Western District of Michigan. He was nominated by President George Bush in 2007 and has been on the bench since then. He was our chief judge of the Western District from 2008 till just about 2 months ago. Prior to becoming on the federal bench, he has a real extensive history. He was a prosecuting attorney for Berrien County for 14 years. He was an assistant attorney general for the Department of Justice for 4 years. He was a district and circuit judge in Berrien County for 12 years. And if that's not enough, he's currently one of only 26 federal judges in the United States that's on the Judicial Conference, which is the policy-making board for all our federal courts. So we're really excited to have him with us today to talk about these new developments. Well, with that, we'll go ahead and get started. This first session today, we do have 2 other panelist members. We have Andrea Bernard and Scott Carvo. They are both partners, senior partners at Warner Norcross. They're both in the litigation department. We're not going to spend a lot of time going through our individual bios today, but they're in part of your packet at the end of your materials. And today we're not going to spend a lot of time walking through each of the amendments that are upcoming. Instead, we've decided to do it more on a case study basis. We provided you in your materials an executive summary of each of the rule changes that are upcoming, and it also has a link or a site on the bottom of page 1 if you want a citation to the full set of the rule changes. Instead, we're going to walk through a case study today, and then what we're going to do, Scott Carvo is going to be our plaintiff's attorney, and we're going to identify we're going to walk through this case scenario, and we're going to ask Scott, in light of the new rule changes, how is he going to approach some of these early stages in the discovery process? And then we're going to ask Andrea, who's going to play the defense attorney, what's her strategy? How is she going to approach it? And then we're going to ask Judge Maloney to often maybe get in the middle of the two and resolve the issue, or just express some thoughts on how he sees these rules playing out. So our case study is pretty simple. We have the defendant is a large corporation, multinational corporation. It's been around for 15 years, has thousands of employees. Scott represents John Smith. He was injured in an automobile accident. He believes the injury was a consequence of a negligently manufactured and designed automobile. So he's filed a complaint against defendant OEM Corporation, and he has filed it, and it's pending before Judge Maloney's court. One of the interesting amendments is with respect to the request for production of documents, and that's Rule 34. And what you'll see in this particular slide is they've moved up when one can serve a request for production. Historically, there's been a moratorium on discovery until you get to the pretrial conference, and typically that pretrial conference would not occur for 3 to 4 months after a lawsuit was filed and served. But now a party is able to serve discovery requests sooner than that. They're able to within 21 days after the summons and complaint are served. Now, it does not mean that the responses are due until after the pretrial conference, but we do now have discovery requests that can be served early on. What we have now is at the start of this case, we've assumed that the complaint's been filed, and we're now getting into the request for production, and Scott has decided to file some early requests for production of documents, and then we're going to set forth these and let Scott kind of talk through what he's going to be asking for, why he's asking for this, and just what's his strategy at this stage of the process.
Thanks,
Scott.
Jay. The interesting thing about these rules amendments now is that they do allow for early discovery requests, and oftentimes we'd go to the Rule 16 in front of the judge, and we'd kind of be talking in hypotheticals. We'd be talking about, well, we think we might be asking for design and manufacture and sales documents, but you hadn't proffered requests yet, so you really didn't have anything specific to base that discussion on, and now you can have that opportunity. So in this case, a couple of interesting things I want to point out that I'm sure Ms. Bernard will point out eventually anyway. The lawsuit in this case is meant to be purposefully kind of vague. My plaintiff, John Smith, was involved in a single car accident, meaning he hit something and he got injured. So who knows what he was up to before that? She'll point that out. But
Or what he was on.
what he was on, whatever. All those kinds of things may be the subject of discovery, but from a plaintiff's attorney's standpoint, if he suspects there's something wrong with the car but doesn't necessarily know, he's going to have to go on a little bit of a fishing expedition. And we'll talk about kind of proportionality and some of these other concepts later in the rule amendments, but what I'm getting at here with these requests are, what's really wrong with this car? So design, testing, manufacture, I'll talk about sales and marketing in a little bit, but other lawsuits involving the car from the 2000 to present. A couple things I want to address here in those requests. One, I'm trying to figure out what's wrong with the car. Was it a brake issue? Was it a starter issue? What's really going on here? Is there anything that I can latch onto in testing results that may make my case from a liability standpoint a little easier? Also worthwhile mentioning that I've pled $500,000 in damages, and that's meant to be kind of a median damage figure, such that discovery of this type might be really, really expensive. And so if I'm going to be asking for documents ranging back 15 years, I might need to figure out whether or not there are other similarly situated plaintiffs, i.e. a class action lawsuit. So that's why I'm asking for sales documents. The other lawsuits also will help me try to ferret out what my claim might be. And so what I'm really trying to get at is, can I make this about more than Mr. Smith? Can I make this about more than $500,000 so that I can kind of push for these? From a timing perspective, to ask for documents going back to 2000 probably isn't going to fly initially, and maybe all of these categories may not fly initially either, but in proffering these requests early, I'm trying to set the table. I'm trying to set goalposts that can be moved in. So I'm going to ask for everything. This company was started in 2000 and started manufacturing cars in 2000. Well, I want records all the way back to 2000, understanding that my opposing counsel is probably going to object. But if I try to say 2 years and what I really want is 1, I might not even get that. So I'm going to try to move the goalpost back a little bit further for negotiation at the Rule 16.
And I think you've summarized on this particular slide some of the strategies I think that you've really just set forth.
Yeah, I really want to have a specific discussion at the Rule 16 as a plaintiff. And another thing to keep in mind when you have an individual plaintiff like this is that he doesn't probably have the same kind of resources that you have available to you either in-house or through your counsel. And so I want to make sure that I have a very specific discussion about this so that I can get exactly what I want. We talked about the date range. I also want rolling discovery, and that's a concept we'll probably get into a little bit more with the Rule 16, meaning I don't want everything at once because I'm going to get overwhelmed. Again, I'm probably at a very small law firm representing an individual here. I'm not going to have the kind of resources available to me that Ms. Bernard will, whether it's using some of the best practices in eDiscovery that I'm sure Jay will talk about later, technology-wise. I might not have the capability to deal with a mountain of documents being dropped on me. So I want to have a sectioned off rolling piece of discovery where I get kind of an initial sample set of documents that I can look at. And that's going to help facilitate discussion about search terms and key custodians because I don't want to be having that discussion in the dark. She's going to know better than I will who her key custodians are and what search terms might be the best to use. But I'm not going to have any idea until I've seen the documents. And I mentioned the fishing expedition that I may be trying to go on here.
Andrea, if you can not necessarily respond to Scott's RFP yet, but give us your thoughts and what you might be asking on a request for production at this early stage, and whether you would do it at the early stage. Are you going to send that request for production before the pretrial conference or not?
I think this change to the rules is really a great change because it does give the attorneys and the judge an opportunity to have an informed discussion at the Rule 16 conference about discovery. So often you go into these things somewhat blind, not knowing what the plaintiff's going to ask for, or even not even really knowing kind of what their theories are on the case. So you kind of go into the Rule 16 blind. If you have early discovery requests, it enables you to have an intelligent conversation with the court at the outset about what may need to be done, produced, relevant, etc. I mean, Scott talks about me having the ability to identify my custodians, but the reality is with the breadth of his discovery requests, my custodians are really going to be the entire company, and that's ridiculous. So I want to go in from my perspective and try to narrow those things back. So as I put together my discovery requests, my strategy is going to be to demonstrate that this accident, this single car accident, nobody else was there to make this thing happen except for this Yahoo. I want to demonstrate it was his fault and not the fault of my car, right? So I want to ask for lots of documents about John Smith in specific so that I can demonstrate that this is his fault and not my car's fault. And the other thing strategically that I want to do as a defendant, as a large corporation with potentially oodles and gobs of data that's going to have to be searched, is I want to demonstrate to the court that I am eminently reasonable in the breadth and scope of my discovery requests, because I am focusing only on those things, or I want to focus only on those things that really are going to be relevant to the case, his claims and my defenses. So you don't see me saying any and all documents related to this exceptionally broad category. What I've tried to do is ask for specific categories of documents that can be easily identified and can be easily narrowed down. And another argument that I have when I go into the Rule 16 conference will be, these are not burdensome to Mr. Smith. He is one individual. He needs to get this information pulled together for one person. That is not a difficult task. He knows where his medical records are. He knows where his employment records are, etc. So I want to demonstrate to the court through my discovery requests that I'm being reasonable in scope and reasonable in my expectations and keeping my requests focused on what really are the issues in the case.
Your Honor, with respect to this new amendment about parties being able to serve these requests for production early, how do you see that playing out? I mean, do you think this will be advantageous? Will it make the pretrial conference more efficient?
Indeed, I do. First, it accelerates the process even before you're getting to see the judge for the Rule 16. And I think to the extent that the length of time that it takes to litigate a case may be shortened, perhaps significantly, depending on what your judge's timing is on their Rule 16 conferences. I think it has a real beneficial effect in terms of accelerating the process even before you get to see the judge. As both Scott and Andrea have said, typically it's a situation where, at least under the present rule, in our court, you meet and confer, you talk about discovery, but there really isn't the level of detail that you have here to inform the judge as to exactly where the clash might be. The other thing it does, and this is another, the early requests also are consistent with the notion that not only does the judge have an obligation under Rule 1 to move the case in a just and efficient manner, but the parties do as well. So to the extent that the lawyers are talking earlier, that I think is extremely beneficial as well. The requests that you see are purposefully across the board. When we were doing the prep on this, we decided that there would be a range of considerations for the judges. I have a instinctual negative reaction to fishing. The fishing better be light. Okay.
It won't be big game fishing.
I mean, we're talking about a minnow here, right? We're not talking about
Right.
We're not talking about a tuna, right?
Exactly.
Okay. But I think it accelerates. I think it accelerates the process very well. You know, I'm not sure that the what I'll refer to as the old paradigm, ask for everything and you'll get 60% of what you want. I'm not sure that's really consistent with the tone that the new rules are trying to set, and the introduction of, in a much more specific way, and highlighting the whole notion of proportionality. I'm not sure that ask for everything in hopes of getting 60 to 75% of what you're asking for is really consistent with the philosophy of the new rule. And I'm going to be as a judge, I'm going to be watching for that. I have great respect for the attorneys when they walk into my courtroom at the Rule 16 conference. They know this case better than I do. They know what they need, what they really need. And what I'm looking for is two lawyers who are communicating and communicating constructively on exactly what they need.
That brings up a good point, Your Honor. Going forward, if attorneys come to that pretrial conference and have not sent out requests for production, haven't really thought about the issues, like you said, you kind of assume that they're going to be doing that. But if they haven't, and they really, in their discovery plan, just say, we'll get to eDiscovery if and when the issue arises. They're not taking. Are you going to push back a little bit at this point in time?
This is obviously an important case. The plaintiff has allegedly sustained some fairly significant damages. The defendant has got concerns, obviously, in terms of the attack on the design and manufacture of their car. So this is not what I'll refer to as a pedestrian case. And I would expect that, given the importance of the case and what's at stake, that the lawyers will have taken that time beforehand. I'm not, given the tenor of the rules, I'm looking for lawyer participation and lawyer communication very early. And certainly by the time you reach me, I'll have some idea what's going on when you file your joint status report under our rules. But if it's obvious to me that we got two lawyers passing in the night, I'm not going to be real happy with that.
Great. As an aside, there are index cards on your table, so if a question does come to mind during the presentation, please write out the question, and at the end, Sharon will pick them up. And
as I'm sitting here listening to this conversation, it didn't occur to me, I'm working on a case right now in New Jersey where the court's pretrial order had a deadline for issuing your first set of discovery requests. You had to do it by a date certain. And in the back of my head, I was thinking, why does she care when I issue my discovery? Now I think I know why she cares, so that you can have those fights early and not have to drag out the discovery in order to have it. Do you envision that in the Western District we would have deadlines for getting things done before the Rule 16?
We have not had that discussion yet, but I would expect, because we pride ourselves on moving our docket as quickly as and efficiently as we can, consistent with the needs of the parties. I would suspect that when these new rules become effective, and we have some early experience with them, that indeed the court may turn their attention to some rule changes to kind of basically take a fresh look at how our local rules are coincident with and moving the case forward consistent with the policies that are set forth in the new rules. I think that's probably a discussion for maybe the first 2 quarters of 2016.
Okay, let's move on to the next stage and talk about some additional amendments. Your Honor focused on that Rule 1 modification. As he said, that the duty to secure a just, speedy, and inexpensive determination is now not just the court's responsibility or the attorney's, it's also a responsibility of the parties. And then you'll see under Rule 16 that pretrial conference, not only, we just talked about the request for production being moved up, the pretrial conference and the scheduling order has all been moved up from about, typically you go to a pretrial conference in 3 to 4 months, now it's going to be 2 to 3 months. Scott, in light of that, and as you go toward that pretrial conference, I know you've talked about some of your strategy on the RFP, but what other strategies are you going to be pursuing when you approach this pretrial conference?
Well, I'm gonna try to be reasonable too, because I know I'm asking for a lot, and in my case, what I really have to do is get some discovery to make my case from a liability standpoint. Andrea, on the defense side of things, will have some defenses that will be available to her without ever getting the documents from my client. But for me, I really need these documents. So maybe I'm going to try to have some conversations with Andrea and move the goalposts in a little bit on my discovery requests. Perhaps I'll back off of the year 2000 and move it up to 2005. Try to do some things where I can demonstrate my reasonableness to the judge, because I know he's going to be looking for that. He's not going to want these any and all requests going all the way back, but I've kind of set them out and filed them before the pretrial conference. Then I'll try to have a discussion with counsel about them, moving the goalposts in a little bit to demonstrate reasonableness. But the big takeaway at a pretrial conference on eDiscovery issues and requests for production of documents generally is, what is the judge's level of sophistication with this? Is he coming from private practice? Has he dealt with this issue recently? How many of these big cases has he really had, or he or she had? Is a magistrate going to be involved in a lot of these discovery issues? Really trying to figure out, who is my audience here? What am I going to be able to get away with, and what's not going to fly? And getting that kind of feel at the pretrial conference, I think, is going to really inform a lot of my decisions on what I'm going to ask for and what I'm really going to push for. I mentioned the need to push for early rolling productions, and I'm going to want to try to tee that up in front of the judge as a discussion point. As defense counsel says, this is a lot. It's going to take a long time. I'll just, come back and say, well, okay, if it's going to take a long time, get me what you can right now. Go in there. You're conducting an investigation. Send me some documents right now so that we can have not just a discussion in the dark about what these documents may or may not be, but we can look at a set now, and we can talk about what you found and how you got it and what processes you went about to get them, so that if we have to have discussions about running search terms or who are the key custodians, we can do that. I also don't want to commit to legal theories, and I know defense counsel is going to try to push me on that because I don't think I necessarily know what's wrong with this car yet. So I'm just going to focus on the fact that this was a single car accident, that my client's very, very injured, and that justice requires that we be able to conduct some civil discovery here. The other thing is, and I think there's one more.
Yes.
I'm going to play the victim card as much as I can to avoid cost sharing, because I do think, and justifiably so, there's going to be a push from the defense side of this case to share the cost attendant to running these search terms and pulling all of these documents. And as Andrea mentioned, it's a kind of a low-risk proposition for me. I mean, I might fight about the subject of some of her requests, but it's not going to cost me a lot of money to get my client's documents together, and it's certainly not going to cost me a lot of money to submit those. And I'm going to focus on that. I'm going to say, Judge, cost sharing really means pay to play now for plaintiffs, like my client who've been seriously injured by this car company's negligent manufacture of their automobile. You're telling me that this guy not only is severely injured, but now he's got to pay to do discovery on what's wrong with this car? That's not right. So, we can have those discussions, and it may end up with me asking for fewer documents. It may end up with some sort of compromise here, but I'm going to fight like hell to try to avoid cost sharing in this case.
I am now going to park a PI at the end of his driveway, and we're going to watch everything he does for months.
Not me, my client.
Okay, Andrea, yeah, I think we're all very sensitive to Scott's woes there. But as you approach the pretrial conference, what are some of your strategies and thoughts?
So my strategies are really counter to what some of his strategies are. Part of my frustration as the defense lawyer in this case is all he said is there's a problem with the car. He hasn't said what's wrong with the car, what he thinks the alleged defect is. How this thing got past the Rule 12 motion, I don't know. That's on the judge. Okay. But I have no idea what it is he thinks is wrong with this car. So when I go in there, I want to push him on what are his theories, what does he really think he needs, because I want to narrow the scope of these discovery requests. His requests are, I want anything and everything having to do, for example, with testing on the vehicle back to 2000 to the year 2000, right? Well, if you remember the fact scenario, this is a car that was manufactured in 2010. So why he would need testing going all the way back to 2000, I don't know. There may be various brake systems, for example, in the cars that were manufactured in 2000 as opposed to the cars that were manufactured in 2010. So he, at a minimum, should have to narrow his discovery requests to whatever brake system was in place in the vehicle at the time that the accident happened. Or if he's going to say it was a steering problem, etc. Candidly, I don't know going into this Rule 16 conference what he thinks is wrong with my car, and that's part of my challenge. And so I'm going to hammer that, and I'm going to hammer it hard, and I'm going to hammer it repeatedly when I get into that conference, because this any and all data about testing is so expansive, I'm going to end up basically, I mean, he's basically not defining what he needs with reasonable particularity as he is required to do under the court rules. What he's saying is, go into your office, open file door number 3, and give me everything that's in there without even knowing what that might be. So I'm going to go in and I'm going to push for theories of liability. I want to know what his damages are and how he's come up with them. I really want to push hard on experts because in my experience, a lot of lawyers, and we're all guilty of it, both plaintiffs' lawyers and defense lawyers, don't think about the expert discovery until later in the game. They don't want to spend the money on it. They don't want to spend the effort on it. But in a case like this, experts are going to be very important to me. So I want to know what his plan is for experts. Who's he thinking he's going to call? How many? And how do I need to start early lining up my counter experts to deal with those people later on in the game? And I also want to, one of the things that I as a defendant, one of the things I'm very frustrated by is the notion of a privilege log. Because when I get, I mean, I know why we have to have them, but when I get these overly expansive discovery requests, you can't prepare a privilege log without having someone go through and put eyes on every document and then fill out a chart with lots of information about every document that you're not producing. That is very labor intensive and very cost intensive, so I want to have a conversation early on about what are we expecting in the way of a privilege log, and when are we going to say the privilege log cuts off, for example? So am I going to be required to do a privilege log in which I list every communication that I've had with my client so that I can say, nope, it's attorney-client privileged? Well, that, in my estimation, is ridiculous. So I want to put some parameters around what the privilege log needs to look like, what it needs to contain, and where it's going to start and where it's going to end, because that's a very labor-intensive process for me. He's not going to have anything in the way of a privilege log. That's all going to fall to me, and that's a very expensive process for me.
Just taking off my plaintiff's cap for a second and putting on my defendant's lawyer cap, the expert part is critical. It's really important, and it often gets overlooked. I had co-counsel in a case a few years ago, a co-defendant who refused to provide a subset of documents to the plaintiff, arguing that they were irrelevant. Well, then he hired an expert 3 months later, and guess what set of documents that expert wanted to take a look at? And he did. And he purported to use them in his report, or try to use them in his report, and let's just say the judge really didn't think too kindly upon that. So you really got to be thinking all the way down the road, like Andrea mentioned. Am I going to be using an expert? What kind of expert discovery are we going to be doing? And having those conversations with your expert rather than punting that down the road because you may be hemming yourself in or boxing yourself into a corner that you don't want to be in.
And again, those discussions are happening very quickly in this case. Your Honor, you've heard a little bit from both sides as we enter the pretrial conference. What are your thoughts?
First, at the Rule 16 conference, one of the gauges that I have for a successful Rule 16 conference is that I have an understanding of how well the lawyers are working together, that they're communicating rationally about the issues in the case. That's not always the case. The lawyers in our district are quite good. With no offense from anybody who is not in the 616 or 269 area codes, sometimes I have litigators who have a distinctly different litigation posture early on or perhaps even through the case. And speaking for myself, if you're not cooperating, I don't appreciate it. So I'm looking for lawyers who are communicating and in good faith trying to come to some agreement on the breadth and scope of the case. I'm looking to try to winnow out the obvious. Plaintiff's lawyer has got 16 different theories of liability here. If there's some, I'm looking at the pleadings, I'm looking at whatever other information that I have. You know, if theory number 13, 14, 15, and 16 appear to me to be ridiculous or so far-fetched that it's not even rational to think about it, I'm going to press the plaintiff's lawyer, press the plaintiff's lawyer on that. Do you really mean to plead count 15 and 16 of your complaint? I'm looking for good faith assertions of theories of liability and theories of defense. And I'll ask the question, do you have a good faith factual basis for that claim? And if I get some wishy-washy answers, then I'm going to be, the trust level kind of winnows its way down with that particular lawyer. I agree with both parties about experts. I think getting your arms around the expert testimony is very helpful early. And I recognize there are going to be cases from time to time when that's not possible. But in the what I'll call the heartland case, you know, in the middle 80% of cases, you're going to have a fairly decent idea in your own head where you're headed with experts. And I'm going to be pressing if I get some, you know, less than specific answers on that particular issue. eDiscovery and the cost of eDiscovery. I am sure you have found, and it's illustrated by what is on the table right now, and I'll circle back to that in a moment. I'm sure you've found different levels of sophistication of judges on the whole notion of eDiscovery and IT. Scott brought his iPhone. I have paper. Okay? It's illustrative of my level of sophistication about IT. Now, there are other judges on our court that are, I don't want to say, you know, highly sophisticated, but they're certainly more sophisticated than me. So if I were you, I'd be taking every opportunity to educate in an informal way, if not in a formal way in the pleadings, educate the judiciary about what this costs. You know, what generally speaking, even outside the specific requests of plaintiff's counsel, generally speaking, what does this cost? And over time, as judges become, because this goes to proportionality and other issues which are attendant to the new rules, over time, an educated judge, a judge who is better armed, speaking for myself, with the sophistication of the process and the cost of the process, I think will benefit the parties that have got issues involving, hey, you know, the litigation expenses in this case are going to be quite high, Judge, and we'd really like you to take control. You've got to, again, speaking for myself, you've got to educate me about that, and I'd urge you to do it.
Excellent. Jump into the third set of amendments that we want to kind of cover today, and that is with respect to Rule 34 and some couple changes you'll see here. Boilerplate objections are explicitly forbidden. Productions have to occur more quickly, and objections, they must state whether certain materials are in fact being withheld on the basis of that objection. So much more detailed thought and effort has to be put into these objections. Scott, with respect to what you've seen in Andrea's request for production, or request for production, how do you see her compliance with these particular new standards?
Well, I'm going to be, from my end, in responding to her requests, I'll take that first. I'm going to be objecting to what I think are the irrelevant requests. She wants psych records. She wants, I think, all pictures that have been taken. You know, she's delving into the personal life of my plaintiff a little too far. I don't know what psych records are going to show, and I'm going to object to that. I'm going to object to anything that I deem to be overly personal here, and designed to kind of humiliate or embarrass my client just for having the gall to sue her company for their negligent manufacture of the car. And I'll be prepared to go to the mat on some of this stuff. I may be willing to compromise on some limited social media discovery in exchange for, you know, dropping the psych records or the arrest records. But I'm going to be prepared to go to the mat for that and ask for a protective order on some of this personal information. As I'm responding to her, though, again, as I mentioned before, the cost is really more on, almost all on her side of the table. And it's not going to cost me much or take much for me to be very specific about what my objections are, what I'm going to be producing consistent with the new rule, and what I'm not going to be producing. And we talked about, or Andrea asked about privilege logs earlier. I'm going to give her everything I can, because this guy is not going to be in possession of very much privileged material, in my opinion. I don't know, maybe he's counseled with me a little bit about the case, and so there may be a little bit of that in whatever he provides to me to produce, but I can give her every level of detail on a privilege log as I can muster, because it's not going to cost me anything. On the other side, it's going to cost her a whole lot to give a very detailed and specific privilege log, because as she mentioned, she's going to need to lay eyes on every single piece of paper, and she's going to have to provide me with more than I'm going to have to provide her. So I'm going to be as forthright as I can within reason, objecting to the personal information, but I'm going to try to give her as much as I can, as quickly as I can, in as detailed of a manner as I can, because I know she's not going to be able to do the same for me without a lot of cost and effort. So I want to be the reasonable person here, saying that I gave her this, and look at what she's given me back. I don't have a specific enough privilege log to know whether or not these documents are truly privileged. I don't know what she's giving me in terms of responses or documents. So I'm setting myself up on the motion to compel side by trying to be as reasonable as I can in responding.
Are you going to bring up a possibility of a clawback agreement at this stage to maybe alleviate some of Andrea's concerns?
Yeah, I mean, as a plaintiff's lawyer, I think that's just reasonable. It's consistent with the law and the rules as they exist right now anyway. So I don't see a lot of downside to being kind of nice about allowing her to produce documents and have the ability to claw them back or ask for them back without being deemed to have waived privilege on them. If that helps me get what I need to prove my case, yeah, I'm certainly willing to entertain that.
Okay. Andrea, what's your strategy at this stage?
So let me speak to the clawback thing. I always put a clawback clause into my pretrial order that we submit to the court, because I feel like we need to have it just in case. But I can't, as a defense lawyer, I can't rely on that as a basis to just open the door to discovery, because let's face it, once the other side has seen the document, I can't bleach that from their brain. Even if they give it back to me, they know the content, and there are ways to try to use that information against my client, even if not through that specific document itself. So even though you've got a clawback provision, from my perspective, that does not alleviate the cost and the effort of having to go through these documents, because even though they give the document back and can't use it, that doesn't mean that they don't know then the content of that document and can't use that content against you in other ways. But certainly I want the clawback just in case something slips through the cracks. So when actually under the rules, this won't change my personal practice that much at all. When I get overly burdensome requests, of course I object to the burdensome nature of the request. But then what I do is I define back to the plaintiff what it is I will produce for them. So if I get a record that says, or if I get a request that says, you know, any and all electronic communications relating to, regarding, from or to the plaintiff. I mean, that's ridiculous, okay? I'm not going to go out and do a broad search across my entire server for this guy's name. But what I will do is I will go back and I'll say, well, what I will provide to you is I'll give you his personnel file, I'll give you any records from his supervisor that are either to, from, or regarding him, etc. So I'll define back to them the scope of what I am going to provide. And I try to be reasonable in doing that so that if we end up in an arm wrestling match in front of the judge, I feel like I'm going to be able to win that match. Because I always want to be the reasonable person in front of the judge. I always want to be the one who took the high road. I also want to be prepared to provide a privilege log, obviously, for documents that I know exist that are not being produced. And I don't have a problem, you know, doing that. But I want to have a conversation with the judge, again, back at the Rule 16 conference, about what the plaintiff really needs and why he needs it, so that I can then narrow the scope of those requests to something that I can practically, for practical purposes, compile and produce in a reasonable fashion.
And I think, tell me if you agree, Andrea, your best practice that you've been applying on how to respond to these, I think that's really what's being required now by the new amendments to the rules.
Yeah, I think that's what the rule amendments are requiring, yeah.
Yeah. Your Honor, what are your thoughts at this stage on some of their objections and their responses?
Well, I think you've got to, from the perspective of the plaintiff and the defendant, I think you had a real good discussion about what their approaches are. The boilerplate objections are now specifically prohibited by the rules. And, you know, I think there might be a tendency for defendants to just object on proportionality grounds and hope that works. That's not gonna work. Overbreadth requests, I mean, there are obviously some that in the materials here where there's just no way that social media accounts for 10 years are going to be granted. But on the other hand, you know, maybe at some point the defendant said something on his Twitter account 3 days after the accident about what happened in the accident, and which may shed light on exactly the circumstances of the accident. So, you know, so the social media one jumps out at me as one that's not going to fly. The psychiatric record, that's easily taken off the table. Well, are you alleging any psychological damage to your client? No. What's your good faith reason why you need the psychiatric?
So let me be clear,
counsel?
Mr. Carvo, you are not making any claim for emotional distress. Is that what you're telling me?
No.
Okay. Your Honor, you see, this is why I need the psych records.
For 20 years?
He's been crazy a long time.
Okay, fair enough. All right. Well, in any event, the discovery requests are going to get trimmed on both sides if it's got to come to the court. And the hope, of course, is that, and this really falls in line with what Andrea said, hopefully the issues are going to be trimmed down and reduced to the point where the judge has a real crystallized notion of exactly what the particular issues are.
Great. We're going to get into our last area of discussion, or the last group of amendments, and that's amendments to Rule 37, which is entitled Failure to Provide, or Failure to Make Disclosures or to Cooperate in Discovery and Sanctions. On page 3 of our executive summary, you might want to pull that up because it sets forth the language, and we're going to walk through here a motion for spoliation and in this particular fact pattern. But the primary purpose of these amendments is really to give the courts and the parties a more detailed and consistent standard to know when spoliation sanctions may be applied. And there's been a lot of different rulings across the country from different courts on when and the type of sanctions, and this is hopefully intended to give everybody a little more solid of a framework on these type of issues. Now, Scott, as part of this case study, thinks he's uncovered some evidence that there may have been some spoliation in this case, and so I'm going to let Scott kind of tell you about what he's learned and why he suspects that.
So we'll talk about the timeline here in a second, but the general thrust of the motion for spoliation is that Ms. Bernard's company had a tester who had the bad business habit of taking the test results and his test reports that he was generating for this OEM Liger, I think is what we're calling the car in question, and putting them on his personal laptop. Bad form for a lot of different reasons. And sometimes he'd back it up to her server and sometimes he wouldn't. But as a result of her very reasonable request for responses to the request for production of documents, she has given me a document that has indicated that he ran a test report. It was negative on the car in some way, shape, or form, but I didn't get the actual test report. I just got a reference to it in an email. And so from a timing perspective, what we uncover is that the accident occurs, I sue, and somewhere after when I sue, a few weeks after, but before she gets my discovery request, this guy's laptop crashes and he loses everything. And so now I've got a document that says there were test reports, but I don't have the actual test reports, and she's telling me they don't exist. So under the new rule, I mean, the big carrot is I want an adverse inference instruction. I want the judge to tell the jury that they can presume that this document would have been harmful to her case. That's the big carrot for me. You know, we can talk about some of the other remedies that may be available to me, but that's where I really want to steer this discussion, because that, as a plaintiff's lawyer, is a pretty valuable piece to me. So under the new rule, it contemplates documents preserving documents in anticipation or conduct of litigation. So this isn't a case where she was supposed to be keeping these materials because she caught wind of a lawsuit and maybe had to go around and issue a litigation hold notice and preserve documents. She'd actually been sued. This company had been sued and now has lost data in the conduct of litigation, which to me, I think is worse. Obviously, she's going to have a defense, and I'll let her speak to that. But test reports are certainly within the ambit of the new rule, data that should have been preserved. I'm suing about a defect in a car, and so test results are hyper-relevant to that, in my opinion. I'm going to consider the pros and cons of a lesser resolution to this. In other words, not asking for the adverse inference instruction, but maybe seeing if I can get her to go to backup tapes. There may be an advantage to that. Do I really believe this is a negative test report? Can I make a lot out of this based on the context of the documents that I've seen? If that's the case, then maybe I do want to push for restoration or replacement, which the rule contemplates, and see if she can hire a vendor, she can go to backup tapes, if there's some other way to get that information to me. On the other hand, if I really think the judge is going to find this conduct to be abhorrent and I'm going to get an adverse inference instruction and that test report may not have said much anyway, I may not push that issue. So I will argue that my client's been prejudiced by not being able to look at this report. How can he cross-examine or take depositions of these witnesses who say that there was something negative in this report, but don't tell me what it is? It has severely impacted my ability to conduct discovery in a meaningful way and examine witnesses in a meaningful way. And so to get that adverse inference instruction under the new rule, I've got to show that she had an intent to deprive. And that's going to be awful hard to do, I think, under the new rules. And I think the part of the thrust of that, if you look at some of the comments, is to really kind of raise the bar for that adverse inference instruction to kind of alleviate some of the pressure that in-house counsel and in-house records departments have felt. When you get sued, do I really have to keep everything? Because what if they ask for this and it's not there anymore? So is negligence enough to show an intent to deprive here? What kind of case can I make in that regard?
Andrea, what are your thoughts on the motion?
So when I get the motion for spoliation crosses my desk, when I get together with the court, I'm going to focus on a handful of things. Number one, I'm going to focus on the timing of when this thing was destroyed. It was very, very early in the process. Remember, I have 10,000 employees. So as the defendant, it is not easy for me to just simply say, oh, here's the 3 people who I need to issue a litigation hold notice to. This is a laborious process for me. I've got to figure out who it needs to go to and what I need to ask them to save. So I want to focus on the timing of this thing and the fact that we were very early in the process when this guy's computer crashed. And the key thing is, another thing that I'm going to argue is, the computer crashed, okay? These things happen. It was an accident. So really what the plaintiff's lawyer is complaining about is that this individual whose computer crashed, he didn't save the computer and try to recover the data that was lost. Because there's no allegation that the crash was intentional, but that he didn't save the computer and try to get the information back through forensic means. So I'm going to focus on the fact that it's very early in the case when this thing happened. I'm going to focus on the size of my corporation and really the burdensome nature of how much it takes for me as a defendant to get that, to identify who the potential custodians are and to get that litigation hold notice out, okay? And then I'm going to focus on the inadvertence of this thing. Because remember, under the new rule, he's got to prove that this was an intent to deprive him of evidence before he's going to get an adverse inference instruction. And remember, this computer was it's not a work computer, it's a personal computer that one of our employees, against policy, albeit, but sometimes people don't always follow the policies. Are you going to punish my client because we have someone who didn't follow the policy, backed information up on his computer rather than having it on the server? So I'm going to focus on that, and I'm going to focus on the fact that the likelihood that anything material was lost is very small. Because remember, this is 2015 when the computer crashes. These were tests that were done in 2010. This employee acknowledges that he regularly backed his computer up to the company's servers. So to the extent that report was on his computer, it would be on the server or already, because the likelihood that there would have been tests from a 2010 car that hadn't been backed up at some point to the server in that 5-year window are pretty small. So I want to focus on the likelihood that there's any material loss to the plaintiff. I want to focus on the inadvertence. I want to focus on the fact that it happened very early in the case and not at a time when we could have been expected to have issued a litigation hold notice to these people, and basically throw myself at the mercy of the court.
Scott, before we ask Your Honor to issue the reply, anything that Andrea has said that you'd like to comment on?
Well, it smells bad. I mean, if you've got a guy who does these kinds of test reports on the regular, and he's only putting them on his personal computer, and we selectively are getting test results back, but not the ones that are negative, it just smells funny. And so that's the kind of, what are they hiding? That's the kind of approach I'm going to take with this. That, yeah, all those things are true in the abstract, but the reality is your company was hit with a lawsuit. I am finding out now that there was a negative test result about this car that you have not given me. So what's up with that?
Well, okay, so just so that you know, when the email said the results were negative, that meant there was nothing there that was bad. The results were negative, right? If you go in and get tested for cancer and the results are negative, that's a good thing.
That is a good thing.
So the results were negative. There was nothing bad. Quit your whining.
But the reality is I got to trust you on that. I have no independent basis to verify that because I don't have the report.
You can always trust me.
Well, Your Honor, before you talk about this particular case, what are your thoughts in general about the amendments to this particular rule? Are you encouraged by them?
I think this amendment is very significant. It clarifies a lot on the issue of spoliation. We had circuit splits on standards of proof, district judges having widely divergent views on, quantum of proof, et cetera. And I think this rule is a major positive change, at least in terms, from the perspective of the judge, clarifying exactly what the issues are. You can argue about, and I've seen some commentary in the press from different perspectives of members of the bar, depending on whether they're representing plaintiffs or representing defendants, in terms of the wisdom of where the rule ultimately came out. That's a great argument to have. But for the judge, it is a clarification amendment, which I think is of immense help. And just to focus on a couple of things. Mere loss, as Scott has pointed out, mere loss is not enough. The fact that something, for sanctions, if you're coming from the defense side of the case and you've got the responsibility of keeping the records, it's going to be ultimately a reasonableness inquiry as to what you did and did not retain. And I think it's going to be extremely important to document what you've done in terms of retention of information after you get the notice of anticipated litigation. I know companies find themselves in a position of either saving everything or doing something short of that. Those are really tough calls. But I think whatever the decisions are, and presumably you're not being unreasonable in making those decisions, if you document exactly what you did internally, then when this motion comes in, you're in a much better position. Okay, Judge, here's what we did. And yeah, Billy Bob's computer crashed, but as Andrea points out, it wasn't intentional. And yeah, Billy Bob should have called somebody before he before he shredded his hard drive or whatever he did to lose the data. But the reasonableness inquiry is going to is basically the umbrella. And I think if you've got documentation as to exactly what you've done, that's going to serve you and serve the defendant in good stead. And then as the other thing I've got to find is prejudice. Now, counsel has effectively said, well, Judge, I've got to trust what they say, that it was a negative test. And now I haven't got the document, or I haven't got the test results that say that could help me in my case. But the prejudice prong of this new rule is also another hurdle before you get to sanctions. And then, of course, the big finding is actual intent to deprive, which I think is going to be a very significant standard moving forward. But to the extent that the rule clarifies exactly what the steps are now for the district judges, I think that's real helpful.
Excellent. Sharon, we're going to roll into some questions. If you do have cards you'd like to turn in, Sharon will grab them. You're also welcome in a minute to just raise your hand and stand up and ask a question. We're fine with that as well. I'll get our panel kind of started on a first question. We've indirectly talked about proportionality. We really haven't focused in on that particular rule. It's Rule 26 on page 2 of your materials. But it clearly states that the issues of proportionality that should be considered early on the breadth of, and burden of discovery are various factors: the issues at stake in the action, the amount of controversy, the party's relative access to relevant information, parties' resources, the importance of discovery and resolving the issues, and whether the burden or expense of the proposed discovery outweighs the likely benefit. Now, as we talked about, we're going to be having these discussions likely at the pretrial conference right off the bat. I guess I'd like to hear from the panel. I mean, is it realistic to be able to evaluate those factors this early in a matter? Do you see problems with that, or is that a good, easy standard to apply?
From a plaintiff's lawyer standpoint, the hard part's going to be knowing really what my damages are in my case, because I think a lot of the discussion is going to be, and these smaller cases, is going to be focused on, you want what now for a $50,000 case? You got to be kidding me. It's going to cost me $200,000 to hire a vendor to run searches across my server, to figure out where these documents are all housed. That's going to be an incredibly expensive process, and it's going to easily dwarf the amount in controversy in the case. So plaintiff's lawyers are going to have to figure out at a very early stage, what do I really need to prosecute my case? How much is my case really worth? And so, yeah, that may be very challenging for certain plaintiff's lawyers. In cases where you're talking about companies suing each other, I think it's going to be a more interesting discussion. I think it's going to be a lot easier to have proportionality and cost sharing than it will be with an individual plaintiff, for the reasons I articulated earlier. Woe is me, this guy has been injured in a car accident. He's now unemployed. He can't pay for any of this stuff, and are you really going to bar his access to relevant information because he can't pay? But yeah, I think it's going to be a big challenge, and plaintiff's lawyers are really going to have to figure out what their case is about and how much it's worth at a very early stage.
I think this is a great development in the rule, because for all the years that I've practiced, the mantra that constantly gets thrown back in my face as a defense lawyer when I say this is overly burdensome and I'm really not looking for anything relevant is, well, relevance is anything reasonably calculated to lead to the discovery of admissible information. Well, that is now taken out of the rule. I can assure you that will remain a part of the discussion among lawyers, plaintiffs' lawyers, and defense lawyers nonetheless, because that has been the mantra for so long, it's going to be hard for us to let go of it. So I'm sure that I will continue to hear and have conversations about reasonably calculated to lead to the discovery of, but that is no longer part of the rule, okay? Now what we're looking at are these new factors that I think, at least from a defense perspective, will be tremendously helpful to me in narrowing things down. The proportionality language in this rule is, I think, long coming. We've needed this change for a long time, because so often as a defense lawyer, my clients find themselves in the position of saying, but it's going to cost me more to defend this case than the amount at issue. So you really have got a monetary gun to your head. You end up having to roll over because it's going to cost you more than it's worth. And the only cases that people can really afford, quote unquote, afford to litigate are the ones that have a bigger picture, where if I settle this one, we're going to get more plaintiffs, or if I settle this one, there are some overriding policy issues that I'm not going to be able to address later. In the smaller cases, defendants are being compelled to settle even though they really didn't do anything wrong. So I think that these proportionality rules are a long time coming. I'm very glad to see that they're in here, and I'm interested to see how they will develop in practice, since so many of us have, for so many years, had that sort of mantra running in the back of our heads.
Your Honor, and I think you've mentioned, I mean, I think the federal court is quite sensitive, the argument that Andrea has made about discovery making courts inaccessible, right? And that's really one of the core reasons for these rules.
Absolutely. If you read some of the history of the promulgation of these rules, one of the driving forces behind the amendments is the cost of litigation and how the real concern that federal courts were pricing themselves out of the market, if you will, for resolution, and by market I mean resolution of disputes, that more and more parties were deciding to go to arbitration pre-lawsuit. They were writing it into their agreements to avoid having to go to court. And the Rules Committee that was chaired by Jeff Sutton of our circuit came to the conclusion, well, that's, you know, the cost of litigation and the fact that people are not using the courts is really inconsistent with our core mission. So to the extent that the proportionality factors are there now, it's to hopefully foster the notion that outcomes, whether they be as a result of a trial or as a result of a settlement, are driven more by the merits of the case than the costs of litigation. So with that said, let me talk about the mantra that Andrea addressed. The lawyers have had this mantra of, well, you know, reasonably calculated to lead to discovery of admissible evidence. Trust me, that's in the head of every federal district judge, every United States magistrate judge who has served for any great length of time. So it is going to take some time for that old rule to work its way out of the system, because clearly the language has been stricken from the rule. It's clear from the commentary that it was purposeful and purposefully designed to try to cabin the nature of the discovery requests. Amount in controversy, a couple of other comments. Amount in controversy is a factor, but there's also language in there to indicate that the importance of the issues in the case are also an issue. Yeah, this might only be a $10,000 case, Judge, in terms of the monetary damages, but there are important public policy issues related to this case, or something else that makes this case more than just a claim for $10,000, and that therefore the discovery needs to be proportional to the importance of the issues related to the case. I think we're really going down a road that's going to be fleshed out over time on this whole issue of cost sharing. My guess will be that many of my colleagues, whether they be magistrate judges or Article III district judges, are going to be issuing opinions on this, and those cases will be winning their way through the various circuit courts. But the cost-sharing notions, I think, to the extent that the field has been changed in terms of the scope of discovery and the new rules regarding scope of discovery, I think you're going to basically have a whole nother generation of litigation and decisions being made on the whole issue of cost-sharing. And that's one where, you know, I think at this point it's really unknowable where we're headed on that particular issue.
Which is ironic, just another layer of cost associated fighting those motions. Yeah.
Indeed.
Right.
Indeed.
We have a very interesting question from the audience. How flexible will the courts be where a defendant corporation has not been able to conduct an internal electronic document search at the time of responding to a discovery request?
Has not been able to?
Has not been able to. I take it, I think they're kind of focusing, and it's probably information on the parties' resources. I mean, I think that's kind of where it's zipping in on now. You might think that, I mean, nowadays you'd be able to do so, and there'll be an interesting argument. We don't have the resources to do a sufficient e-discovery search as a lot of large organizations and law firms are now able to do, and it's expensive. And just wondering what our panel thinks about, is that going to be a sensitive argument, or is really this technology becoming so common and that it's really not something that can be ignored anymore?
Well, I think the question really addresses more than just the technology, too. The federal rules give you 30 days to file an answer, which would seem like a lot of time, but in the big picture, 30 days is not a lot of time. Busy people are in and out of the office. You've got to figure out who's got the documents, where they are. That you got to run the searches. You got to capture the documents. You've got to scan them in. You've got to review them. You've got to redact them. You got to do your privilege log. 30 days is not that much time. But I will say, in my experience, what I endeavor to do is get my answer and my objections out within 30 days, with the expectation that I'll get the documents to you as soon as I can. And at least among the attorneys in the Western District of Michigan, people are very accommodating in that regard. I very seldom have a plaintiff's lawyer who will call and start busting my chops because I haven't made the documents available to him or her on the 31st day. That's not always the case when you're dealing with people from outside this district, but I think 30 days is not really 30 days in the practical reality.
Yeah, and I'll be curious to hear what the judge thinks of this, but just the question and thinking about the cases that I regularly litigate, I think a lot of it's going to have to do with your company's policies, how well documented they are, how reasonable it is for you to not be able to do that. So if your company, for example, is like the judge, much more paper-friendly than anything else, and you've got large file cabinets and you don't want to conduct a search of your email system because you think there's nothing really relevant there that's not already captured in my files. That may very well be reasonable. So a lot of it's going to depend on how your company's policies are, what your systems are, what your technology is, and what your sophistication is. And also, is this a case that really lends itself to email discovery? Do we really need to do that? Do we really need to run searches across the server? Do we have a shared file system where relevant documents may be saved? It's going to depend on the facts of the case, I think.
Although I think we all would know that if that's what the party's position is going to be, that, boy, we print everything so we don't need to do electronic search, when the depositions come around, those questions are going to be asked. And they're going to be seeing whether actually the real practice is complying with what's been laid out as the policy and practices of the organization. So,
Indeed. The interesting question. Frankly, I haven't run across that, at least on my time on the federal bench. I think it's going to be based on the record that you make. Have you documented what you've been doing? And it's going to be a balancing test between the need for the information and the costs of getting the information out. Again, if this is a $5,000 case and you've got file cabinets full of paper documents, I can relate to that because this is obvious, I'm a paper guy. But on the other hand, in modern day, over time, that's probably not going to cut it, especially in a big case. So I think if you find yourself in that sort of situation, you might want to start thinking about allocating some resources to get your IT systems up and running, because clearly that's the trend.
next question. How are the state courts dealing with these same discovery issues?
They're not.
Not officially, right?
Not officially and not yet. It is more difficult to get kind of the reins pulled in as a defendant's lawyer in these state cases. But again, it depends on some of the judges that you draw and their level of sophistication with these issues. But I find that it is a little easier for me to get some balance, some structure, and some relief in federal court, because the judges, even under the old rules, had more of a mechanism in place to deal with these sorts of things. But yeah, depending on where you're at, what judge you draw, you may get someone who is not sympathetic at all to the costs involved and just thinks, yeah, what the heck, you should be able to search your servers and produce everything. So it can be a lot more challenging in state court. I expect there will be some runoff from these rule amendment changes, especially as they gain traction and success, that there will be some modifications done on a state level, but we're years away from that.
Well, and I think we also have to remember our fact scenario that we're dealing with here is a personal injury case of an individual who got into a car accident manufactured by a large corporation. But the reality is a great many of the cases that get filed in federal court, at least, are large commercial litigation matters between two corporate behemoths. So sometimes the proportionality discussion is really not so one-sided and needs to be more of a practicality rather than a proportionality discussion.
Right.
Because I've certainly been in cases where you've got two large corporate entities who both seem to have a nearly, I won't say unlimited level of resources, but nearly unlimited level of resources, and it is not a productive use of your money. It really isn't. I'll tell you who makes the money on that is the lawyers. It's not a productive use of your money. So you've got to start at the outset laying reasonable ground rules for what you're going to get and what you're not going to get. Otherwise, it's just going to run away from you.
Excellent. We have time for one last question. Should the courts continue to follow the readily accessible threshold for limiting the scope of electronic documents when those documents are stored offline? Or is the more easily, the point of this is these, what used to be inaccessible data sources are becoming more accessible. Do we see changes in that trend?
I think so. Given the nature of technology, I think it's going to be real hard to convince a judge that it's not accessible. Over time, when you talk about servers that are allegedly wiped clean, and yet data is retrieved, judges hear that sort of commentary in the press, so inaccessible. I think that's a hard road to hoe.
There's a lot of levels to that too. And what I would say is have a defensible retention policy. Talk to Dawn if you don't have one already, but really think about having a conversation between IT and your in-house legal and your lawyers about what you're doing, what your practices are, and what is really readily accessible. And the best thing you can do is be informed about that, and also be informed about the cost, because that is going to play a role. And if you can go to Judge Maloney and say, could we get this? Maybe. There's a chance, but here's how much it's going to cost. And that's really not reasonable under the circumstances.
Great. Well, we're to the end of our first general session. For informational purposes, we have decided that we will be having another symposium probably in March. What we've decided to do is we'll do back-to-back. We'll do maybe mid-March on the west side and a couple weeks later on the east side, so we don't have to have people necessarily driving from Midland and Detroit over here. And so, but we're at least going to continue to have one of these per year. We don't have paper evaluations. You'll get a Survey Monkey email from us later today. Please fill that out and tell us what you want, not only how you thought today went, but what you want to see for the future. We have about a 10-minute break, but I really want to thank our panelists today for giving us the time and effort, both preparing for and today's presentation. It was very good.